and welcome everybody to this webinar about the study questions 2023 of the AIPPI. My name is Thomas Widmer. I am an attorney at law specializing in IP. I work with Lalive in Geneva, Switzerland, and I am a member of the board of AIPPI Switzerland. I'll have the pleasure to moderate this webinar organized by the Swiss group of AIPPI with the support of AIPPI International about the study questions and resolutions of 2023. I'll start with a few words about AIPPI for those of you who are not familiar, who are not members of the AIPPI. So AIPPI stands for the International Association for the Protection of Intellectual Property. It is the world's leading non-profit association dedicated to the development and improvement of laws for the protection of IP. It is an association based in Switzerland with over 8,000 members worldwide. So the AIPPI annual congress was held in Istanbul a few weeks back, so in October last October actually. And as always, 4 resolutions were adopted based on reports submitted by national groups, including the Swiss group. Approximately between 30 and 40 reports were received. This year, the resolutions were about doctrine of equivalence, proving trademark use, collecting societies, and responsibility of online marketplaces for online infringements. As some of you may know, these resolutions are being sent to WIPO, to WTO, and to patent and trademark offices around the world with the objective of developing international IP law and harmonizing national IP laws. So this webinar will provide a thorough analysis of the Swiss reports and the corresponding resolutions that were adopted at the World Congress a few weeks back. Before starting, a few housekeeping rules. So during the presentations, please mute yourself. If you're comfortable to do so, please feel free to leave your camera on during for the duration of the webinar. There will be a short Q&A after each presentation, so please refrain from asking questions during the presentations themselves. Please note that today's webinar is being recorded, and if you encounter any technical problems, please send a message in the chat box to AIPPI. So our first speaker today is Joseph Schmitz, who's a patent attorney with Isler and Pedrazzini in Zurich, Switzerland. And Joseph will speak about the resolution and the reports concerning the doctrine of equivalent study question. So without further ado, Joseph, the floor is yours.
Thank you, Thomas, for handing the floor over to me. Welcome, everyone. Thank you for having me. And though I will be the one presenting the Swiss report today, I am by no means the author or sole author of this, as you can see on the slide that you should be seeing right now. There were multiple other patent attorneys from Switzerland that were involved in the drafting and in the submission of the Swiss group report regarding the doctrine of equivalence in the framework of Q284 of this year's AIPPI World Congress in Istanbul. So without further ado, I will move on to the next slide and briefly talk about the doctrine of equivalence in Switzerland. As most of the people on this call will know, on a European level, the concept of the doctrine of equivalence is enshrined, let's say, in Article 69 of the EPC in conjunction with Article 2 of the protocol on the interpretation of that article, where at least the word equivalent is named expressis verbis at the end of the sentence. On the other hand, on a Swiss level, the Swiss Patent Act provides for legal basis for the doctrine of equivalence, not by really mentioning it by name. As you can see here, any person who uses a patent invention unlawfully is considered to be liable under civil and criminal law. But that is kind of literal infringement. What we in Switzerland call equivalence is actually laid down in the law as by the term of imitation in English. In German, it would be Nachahmung, in contrast to Nachmachung, and in French, imitation and imitazione, I think in Italian, if I pronounce that correctly. On the topic of jurisprudence that is provided in Switzerland, the Federal Patent Court has actually, ever since its inception, provided rulings that concern the doctrine of equivalence. The first that was put out there and provided, I'm going to say, a first draft of the 3 questions that are notoriously asked in proceedings in Switzerland, the 3 equivalent questions. Those were laid down in the first version in the Dros-Pyrénon case, and were followed and amended in the framework of the ensuing Urinalventil decision, where the federal court decided to at least partially reverse the decision of the Federal Patent Court, and also provided for yet another version of the second question. After that, it went back to pharmaceutical subject matter in the context of the Pemetrexed saga, which of course has its national equivalent more or less all over Europe. And also here, the Pemetrexed decision by the Federal Patent Court regarding the doctrine of equivalence was sent an appeal to the Federal Court, which reversed that decision as well. And lastly, this year's De Ferasirox decision, which was also regarding the doctrine of equivalence and was also confirmed by a judgment of the Federal Court of last month. But turning now to the actual report of the Swiss group regarding on question Q284, it bears to mention that this is actually not the first instance of AIPPI discussing the doctrine of equivalence topic. That topic has been already addressed in 2 prior resolutions, which were Q175 in 2003 and Q229 in 2012, which dealt with the doctrine of equivalence. And really, this year's exercise seemed to be to provide a, let's say, update on the evolution or devolution, whatever you want to call it, of the doctrine of equivalence in the Swiss national context. So basically what the questionnaire was asking was to compare the existing tests and exceptions that were laid down in the previous resolutions and see if there was any difference. The first test that we were asked to give our opinion on was the 4A function test, which means that the elements under consideration in an allegedly infringing product perform substantially the same function to produce substantially the same result as the corresponding claim element. And the Swiss National Group was of the opinion that this function test was indeed being practiced under Swiss practice because it corresponded substantially. You'll hear a lot about substantially, the same as the same effect question, which in German we called Gleichwirkungsfrage, which corresponds to the first question to be asked in the assessment of the doctrine of equivalence, the scope of protection under the doctrine of equivalence. Also, the questionnaire wanted to know if the Swiss group was under the impression that there was any need to amend or change that function test as laid down in the previous resolution. And the answer in this case was no. Following the discussion about the 4A function test, there was the next test, the 4B difference test. And that one meant that the difference between the claimed element and the element under consideration is not substantial according to the understanding of the claim by a person skilled in the art at the time of the infringement. And in this case, the Swiss group was also of the opinion that this test was indeed being implemented under Swiss practice because it substantially corresponded to the second question that is asked in the assessment of the scope of protection under the doctrine of equivalence in Switzerland, which is the Auffindbarkeitsfrage, which in English, according to the translation provided by the Federal Patent Court, is to be called the accessibility question. And it will then come as no surprise that the Swiss group did not consider that there was any need to amend or change that 4B difference test as already previously laid down 20 years ago in Q175. The tests being discussed, it was now the turn of different exclusions mentioned in the questionnaire to be discussed in the context of the Swiss law. And there were 3 exclusions that we were asked to provide our opinion on. The first being the 5A exclusion, which meant that a person skilled in the art would at the filing date have understood an element to be excluded from the equivalent scope of protection. That is indeed the case in Switzerland, although the and because there was so far no definite decision, no final decision by the Federal Court of Switzerland on the matter, but it would most likely follow the principles laid down in the occluder decision of the German BGH, where the principle of disclosed but not claim applied. And again, it will come as no surprise that the Swiss group did not suggest that there was any amendment or change needed for the 5A exclusion as laid down previously. Next was the 5B exclusion, and there the discussion was whether, as a result of adopting the equivalent scope of protection, the scope of protection covers the prior art or that which is obvious over the prior art. Here, what the Swiss group understood was that this question was really whether we do have the Formstein-Einwand, as it is known in German, as named by by the BGH in Germany, if that Formstein principle does also apply in the framework of assessing the scope of protection under the doctrine of equivalence in Switzerland. And that was the case because one older but still standing decision by the federal court affirmed that Formstein defense was actually permissible. And so again, the Swiss group stated that we have the Formstein defense and there was no need to change the wording of that exclusion, at least in our opinion, for Switzerland. The last exclusion that was discussed was the 5C exclusion, which meant that the patentee expressly and unambiguously excluded an element from the claim during prosecution of that claim to overcome a prior art objection. The Swiss group was, in its report, was of the opinion that that particular question, although it had been addressed in some way in the decision regarding Pemetrexed by the federal court, is yet unresolved in Switzerland because the Pemetrix-Sid decision did in fact not hinge on the question of whether there was a limitation of the claims that was a result of a prior art objection. There had been a limitation of the claim, but it was not due to a prior art objection. And the federal court judgment did indeed state something about the case where where the limitation was due to a prior art objection, and stated that that would probably be considered an abuse of right and therefore excluded under the scope of protection according to the doctrine of equivalence. And of course, the group said that 5C exclusion, the wording of the 5C exclusion is fine with us. There is no need to change it. And finally, there was a lot of discussion in the questionnaire where the AIPPI tried to explore the concept of between the scope of protection under the doctrine of equivalence and the assessment of validity and patentability of a patent. And here the question was whether it factually is or whether it should be the case that for the purpose of novelty, inventive step, sufficiency of disclosure, added subject matter, or even plausibility, whatever that means to you, or DPO, if one should look into the scope of protection under the doctrine of equivalence when assessing any of these criteria of patentability. And there, the Swiss group was of the rather strong opinion that this is comparing apples and oranges. And so the answer was no, 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 all through the questionnaire, with a final emphasis that these things are to be kept separate and are not the same. So the aim of this exercise was to decide whether the principles adopted in resolution Q175 were to be confirmed or somehow amended. And even though it was amply discussed during the plenary section in Istanbul, and multiple amendments were brought forward and voted upon, none of those really made the cut. And the resolution that is 20 years old was substantially amended, substantially kept as it was, with the one small exception that the 4A test was amended to include yet another instance of the word substantially. And so if you can, as you can see, the wording is now the element under consideration performs substantially the same function in substantially the same way to produce substantially the same result as the claimed element. And the addition is that the same function is performed in substantially the same way. So you could say that the resolution Q84 has become more stringent, at least with respect to that 4A test, after much debate, discussion, and voting in Istanbul. And with that, I think I have already finished my presentation, and I think we're more or less within time. So I may have any questions that I will try to answer to the best of my ability within the given time framework, if there are any.
Yeah, Jose, thank you very much for the very clear and interesting presentation. Perfect timing, as you said. Now, indeed, we open questions from the audience, so don't be shy. If you want to ask questions, just unmute yourself and ask the question orally. There's no need to use the chat. So do we have any questions from the audience? Doesn't seem that we have. Your presentation was just clear enough, Joseph.
Okay.
I think I might have one very, basic and general question about the use of the terms, actually, doctrine of equivalence. I understand that in Switzerland, it is not included as such in the law, but do the Swiss tribunals refer and indeed, use these terms of doctrine of equivalence, or do they merely refer to the words, imitation, for instance, if we take this example?
Well, the decisions clearly state that there is such a thing as a doctrine of equivalence, and there are Äquivalente in German, and that there is a certain structure to assessing the question of whether there is imitation, but of course everybody calls it equivalence, and the courts use that word as well.
Okay. Do we have any other questions from the audience? If this is not the case, we can, thank you again very much, Joseph. We can now
Thank you.
move forward to the next presentation. So you can stop sharing your screen, Joseph, thank you. And our next speaker is Louisa Galbraith, who is an attorney at law with MLL Meyer-Lustenberger Lachnan-Frerip in Zurich, Switzerland. And Louisa is also a member of the board of the Swiss group of AIPPI. So Louisa, you will talk about proving trademark use. We look forward to your presentation.
Yes, thank you very much. I will try to share my screen. Can you see it? Good, perfect. So also a warm welcome from my side. I will be presenting this year's question on the trademark field. It was about proving trademark use. So quickly to the background, what was included in the question was actually everything about genuine use requirements. So the use that has to be shown or proven by the trademark owner in order to maintain his trademark registration. What was not encompassed in this question was proving use, for example, to acquire distinctiveness or even to show reputation of a trademark or show that it's a famous trademark, or even for proving infringing use. So this was not in scope. We know that 41 reports have been received from national and regional groups. The Swiss group consisted of the people you see down here on the slide. It was a very big group and a very good cooperation. And also our report will be published in 2 parts because it was too long, I'm afraid, in 2 parts in the SIC. So if you want to have a look, you can find it there. Since there were quite many questions, I cannot go through them all. However, I would like to talk about a few topics that were seen as the most important one of this year's questions, maybe also in viewpoint of the Swiss group. One of those was the use of trademarks in virtual worlds, such as, for example, also in the metaverse. I think that's a topic that's very popular at the moment, a hot topic that is talked about in many conferences also. Then maybe a lot against the background of the COVID pandemic, there were questions about the legitimation of non-use, especially in extraordinary circumstances such as pandemics. And maybe the last topic is nothing that was specifically encompassed that much by the questions. However, it was very important to our group because we as attorneys at law, we see quite often that our clients have problems in collecting the use evidence that's necessary. That's a very burdensome task and very time consuming. And there we just also talked about whether there's any helpful technology with this respect, also against the developments of AI and so on. So I will start with presenting some questions concerning those topics maybe also, and the answers of the Swiss group, maybe also tell you about our discussions, and then I will also go through the resolution that was then adopted. So one of the interesting questions was, or that's always one of the interesting questions in those study questions, is whether we consider the current Swiss law or practice relating to the genuine use as adequate. And the Swiss group thought that generally Swiss law is adequate. There are actually no too strict formal requirements, such as notarization or anything to prove use. There's also no strict limitation with regard to the type of proof. Generally, all types of proof are accepted, and then they are looked at for their content. However, we were somewhat, we agreed that the practice of the Swiss Trademark Office of the AIPPI sometimes is a bit strict, although the law is not too strict. So they seem to have quite high standards for proving genuine use. Also, one specific example was that they have quite high standards when it comes to a modernization of a brand, of a registered trademark. And we all know from our clients that they tend to modernize their logos, for example. And we also know that the IP has quite high standards to accept such new logo as still consisting use of an older type of this logo that is registered. What was considered desirable by the Swiss group is that there would be more practical guidelines, also including examples from the AIPPI regarding genuine use. And also, there was a very specific one, a clarification whether a blockchain proof of use could be accepted or not. Then the next topic I already talked about, that's this topic about the virtual world. And here we also had to answer the questions whether the rules in Swiss law are sufficient against the background of those very new technologies and new developments. The group was agreed that actually in the current law itself, in the written law, there's no change would be necessary regarding the use of trademarks in the virtual world. However, that of course the prerequisites of genuine use in such environments would have to be developed by practice, also by the trademark office and the courts. One question we discussed was whether, of course, the use in the virtual world extends to real world goods and services. And here, that's actually what the result was of our discussion. So we discussed that actually if especially services are services that for which a trademark is used in the virtual world are not linked to the physical world, then the use in the virtual world should be deemed use for the actual service. This would be, for example, where someone in the virtual world provides a service such as, let's say, financial advice by means of an avatar directly to you. However, if goods, that's probably especially for goods or also for services, are linked to the physical world, with services, you could think about physical therapy or goods providing food, also foodstuffs. And then the use for the virtual goods and services would usually not extend to their real world their real world counterparts. And this is usually probably the case. However, if I sell, for example, food over a virtual world that is then sent to you physically, then of course, again, it should be a considered use also in the real world. And interestingly, the Swiss Trademark Office just issued a draft for a new chapter in their guidelines regarding this question, although this is about classification of goods, but we can, or classification of services, but we can see here that they seem to share a similar view that could also be adapted to the use of trademarks. So they say if a service in the virtual world serves the same purpose as the service in the real world, such as I said, financial services, then they should also be qualified as those services, so in class 36 in this example. However, if the service in the virtual world serves a different purpose, such as entertainment purposes, for example, then a different classification is necessary. So if I have in my virtual world, if I have a restaurant that does not actually send food to you physically, but in which you can sit with your avatar and chat with other people, this is of course not a use in class 43, but possibly in class 41 for entertainment services. And I think that this suggestion of the AIPPI regarding classifications might also be a first suggestion on how the use of trademarks could be viewed in the virtual world. So this draft is in consultation. The deadline to do so ends actually today, and we will see how it will be adapted. Then another topic that I talked about before was especially about proving trademark use during such widely known events and such as the COVID-19 pandemic. There the specific question was whether the burden of proof on trademark owners should be the same during such events. And the group agreed that this is generally the case. However, always the circumstances in the individual case should be taken into account, such as also the industry of the trademark owner, because as we all know, certain industries were completely shut down by the COVID pandemic. So trademark use was probably not possible in that time. However, in other industries, the use was still perfectly fine, and they even ended, and those industries even thrived during the pandemic. So this was actually what we answered. Then I come to the adopted resolution. I will probably not discuss everything in very much detail, but you can also see for yourself. I will also send you the slides, or we will send you all the slides afterwards. So as you can always see by the green mark and the Swiss flag, this is always the opinion of the Swiss group, and this is the resolution that was adopted in the end. So we were also of the opinion that actually there should not be a quantitative or a minimum level or duration threshold for the evidence required to prove genuine use. This means that you must not provide, for example, 10 documents at least to prove genuine use, but that it's always a question of how those documents are assessed then and what they actually say. So it can be possible that only one document is enough, but it's also possible that you need 50 to prove the use depending on the document. Then we also agreed, and this is also already the case in Swiss law today, that there should be no restrictions on the type of acceptable evidence to demonstrate use. Again, the types of evidence and the content of the evidence should be viewed in the overall circumstances of the case, and also regarding every individual case. Then the resolution number 3 was that reputable or well-known trademarks should be subject to the same evidential requirements for proof of use. We generally agreed on that. However, we said that there is an exception to this principle, that if it is notoriously known by the court or by the trademark office that looks at the use, that the trademark is used. So it's a really trademark that is probably famous, and everyone knows that it's used. Then this was number 4 was about what the evidence of use should indicate, the formal requirements, if you want, whether it should indicate the place, time, extent, and nature of the use. We also agree with that, especially the date is very important and the place for assessing genuine use. However, we also agree that not every specific document or piece of evidence should have or must have a date. If, for example, you can show by other evidence, by accompanying evidence, that it was used in a certain time frame or to a certain extent. Where we did not quite agree was whether the law, or not the law, maybe yes, but the practice not, whether the practice should be more strict before courts than before the trademark office. We thought in the Swiss group that the practice before the IP should be a bit less strict, since it's also the idea of Swiss law that in the end the courts decide on the final validity if a trademark is challenged, and also the proceedings before the AIPPI, position proceedings, and also cancellation proceedings. They are quite short, they are quite cheap, and so we thought that they should also, that the practice should be a bit less strict, and that in the end, actually, the court should decide. Exactly. Then this was the next question was about what I talked about before. So how long, if you change your trademark, is it still considered to be genuinely used? Here we agreed, we had to agree on the prerequisites that should be looked at, or the factors that should be looked at when determining whether a trademark is still the same or not anymore. I don't think that I will go into those in much detail. Here, that's again about the same topic. So here we had to discuss what changes of a trademark should be viewed as not altering the distinctive character, meaning that when those changes occur, that the trademark should still be seen as genuinely used. Here, for example, we have if non-distinctive elements are added to a registered trademarks, or if the layout of the different elements of a mark is changed slightly. For instance, if you have two logos in a trademark and they're turned upside down, that this should still be considered the same trademark for the topic of use. Then we talked a lot, that was also in Istanbul, a very important topic about this online use and metaverse and virtual use. There was also a lot of discussion whether online use was different from virtual use of a trademark. So questions 8 and 9, they now are only considered to cover the online use, meaning on the internet, on a website, or in social media, but not in a virtual world. Here we generally also agreed with the resolution. In question 9, we had to discuss the factors that should be considered when discussing online use of a trademark. Here it's always important to know whether the sale of the goods are made in the relevant public, are made to the relevant public from the respective jurisdictions. Whether also the content of the website targets this relevant public, yeah, so you can see the rest by yourself. Then we have those virtual world questions, which I talked about already. Here also we had to list the factors that should be relevant. They are very similar to the ones discussed before for the internet views. For example, whether the relevant public has access to the virtual world or metaverse where the trademark is used. And then the questions 12 and 13 are then about the topic about especially the COVID pandemic, and also other legitimations for non-use of a trademark. That was actually a topic that was agreed by almost all countries, that such things as force majeure, policy restrictions, and especially also the requirement of a mandatory license. Here, that's typically the case for marketing authorization holders of drugs. So a certain drug can only be put on the market, and thereby the trademark can only be used once the seller has a marketing authorization. And if that takes a long time, he cannot use the trademark. So that was also something that was agreed upon by almost everyone. And then the last question is about COVID, the COVID pandemic again. Here, everyone agreed that during the COVID pandemic, actually the burden of proof should be the same. except that there should not be the need to prove that the fact that such an event actually happened, that you do not have to prove, but still you have to prove that by that event you were prevented from using your trademark. Yeah, so I'm already through. And if you have any questions, I'm happy to answer them if I can. Yeah. I think you're still on mute, Thomas.
Sorry. Thank you very much, Louisa. Thank you. Very, very interesting summary of the Swiss reports and the corresponding resolution. Do we have any questions from the audience? If this is not the case, I do have a question, surprisingly. I see that basically the only point of the resolution where the Swiss group disagreed was about the criteria to be followed by, on the one hand, the trademark office, and then on the other hand, the courts. You believing that the trademark office would have to be less strict because at the end, the question has to be resolved by the courts. Do you remember if Switzerland was isolated in this regard, or if you had, support from other groups?
I feel like maybe there were some other groups, but this was something that was probably Switzerland was quite isolated. I feel like it is because, as I said, you also have quite a easy and cheap possibility of canceling a trademark for non-use in Switzerland with the cancellation proceedings that are office proceedings and not court proceedings. So we felt like it would only be fair if it would be a bit easier on the trademark owners to prove their use there. And also in opposition proceedings, the counterparty can only actually assert that you're not using the trademark, and then as a trademark owner you have to prove evidence, and in opposition proceedings this is as far as I know only prima facie evidence, so it's just not the same as before a court, and this is probably also already done a bit in Switzerland, so we are quite yeah, I think that's where our agreement came from, that it would be the case.
Thank you very much. Do we have any other questions from the audience for Louisa? Well, it doesn't seem so. So thank you very much again, Louisa.
Thank you, Thomas.
Now this is time to listen to Fabian Wigger, who is an attorney at law with Weinmann Zimmerli in Zurich, and Fabian will talk about collecting societies. So the study question number 286. Fabian, the floor is yours. You are muted, Fabian.
Thank you, Thomas. Yes, Q286 is something special. It's the very first time that a study questions and the resolution is devoted to collecting societies. And yes, actually the topic is ideal for such kind of multinational analysis because the collective management of copyrights and related rights is of a truly international nature. Collecting societies have always maintained transnational cooperation. For example, Switzerland's largest collecting society, Suiza, has celebrated its 100th birthday this year. And since its very beginning, Suiza has entered into reciprocal agreements with foreign collecting societies. On the one hand, to ensure that rights in Swiss music are also managed abroad. On the other hand, to be able to license towards Swiss users a repertoire that also includes titles of foreign authors. This international character of the collective management of copyrights has, to some extent, favored an alignment of the respective national legal regimes. Nevertheless, the role of collecting societies and the regulatory framework surrounding them varies considerably from one country to another. The European Union therefore identified the need to harmonize the regulatory frameworks for collecting societies within a directive that came into force a couple of years ago. Now, also the AIPPI country groups identified a need for harmonization. 35 out of the 36 of the country groups who submitted a report found harmonization in this field desirable. This included the Swiss group, which, notwithstanding its openness for harmonization, also stressed that any harmonization in this field must also take into account national peculiarities, such as the size of the local markets, cultural aspects like languages, and so on. The result is a resolution that was adopted in Istanbul that sets some kind of minimum standards national legal regimes should have when they are regulating their local collecting societies. It's not my intention today to present to you the entire resolution. I will rather limit myself to a few key aspects. For each of these aspects, I will also address the current situation on the Swiss law, just to find out whether AIPPI's resolution gives some need to action for the Swiss legislator, or whether there is already anything fine with the Swiss law for collecting societies. I would like to start with paragraph 2 of the resolution, which is titled Scope of Regulation of Collecting Societies. It's kind of an umbrella clause which outlines the various objectives of a harmonized framework for collecting societies. And if you read through that clause, you can see that some of these objectives serve mainly the interests of the right holders who entrust their rights to the collecting societies, while other objectives are mainly for the benefit of the users. The users want to obtain licenses from the collecting societies. I would like to go through the different objectives mentioned in the paragraph and look how Swiss law currently addresses these issues. Fair remunerations. Right holders should get fair paid for the use of their rights. This already is a fundamental principle of the Swiss law on collecting societies. For example, Article 60 of the Swiss Copyright Act says that the rates in the tariff have to ensure that the right holders get fair remuneration. Another thing that's important for AIPPI is that right holders receive equal access to collecting societies. What we do not want is collecting societies who are only open, let's say, for big right holders. But what we want is collecting societies who are open for every kind of right holders in a specific field. Also, this objective is adequately reflected on the current Swiss law. The principle of open doors is a fundamental principle of the Swiss regulation on collecting societies and implemented in every collecting societies in Switzerland already. Fair distribution. Of course, collecting societies collect, but they are also intended to distribute what they collect. And this has to be fair, of course, and Swiss law provides a number of instruments to ensure that kind of fairness. On the one hand, some, let's say, formal instruments. Collecting societies have to draw up a distribution plan, which has to be approved by the supervising authority. And also, let's say, material instruments, guidance on how distribution should be made. And here, maybe the most important principle is the principle of causality, meaning that if you have a song that is played very often on the radio station, you should receive more than if you have a song that's only played once in a local radio station in the canton of Graubünden. Efficiency, transparency, good governance. These fundamental governance principles are also addressed in current Swiss law on collecting societies. And they are also supervised by the supervising authorities. So also something that's already addressed under Swiss law. Maybe let's turn to the objectives that the resolution states, mainly for the users' interests. Predictability. Users should know when they have to pay something to the collecting societies. And if they have to pay, they should also know how much they have to pay, and this how much should be reasonable. All these aspects are mainly addressed under Swiss law in the context of the so-called system of tariffs. I will come back to that later. Also, the resolution wants that it's easy to obtain a license from a collecting society. Also, this is addressed on the current Swiss law. While in Switzerland, we don't have a licensing obligation for collecting society, as we have, for example, under German law. But we have a very strict principle of equal treatment, which leads to the result that if a collecting society starts licensing for a certain type of use, it is obliged through the principle of equal treatment to grant that license to every other who wants such a license as well. So also here I can say that current Swiss law already addresses this adequately. Well, at the end of the day, one must also be aware that these different objectives, they can be in tension sometimes. So what is fair remuneration for the right holders might, in a user's perspective, be unreasonable. What's a fair and detailed distribution might, in an overall perspective, be inefficient. So it's clear that in practice, not all these objectives can be implemented in the same way, but what's necessary is to find a reasonable balance of all these objectives and interests. But all in all, I would say that current Swiss law is compliant with what AIPPI suggests in its Q286. I would like to move on to paragraph 3 of the resolution, which addresses an interesting topic. If more than one collecting society is available, right holders shall be free to select a collecting society of their own choosing. The interesting part of this paragraph of the resolution is the first one, if more than one collecting society is available. And this is really something the Swiss group insisted on, because what we did not want is AIPPI requesting from the different states to provide for multiple collecting societies in each field, just to allow right holders to choose. Because especially in smaller countries, it would be just inefficient to provide for multiple collecting societies just to receive some sort of competition. But the markets here are just too small that they would allow existence for multiple collecting society within the same field. So it is on the current Swiss law a condition that only one collecting society per category of work receives a license from the supervising authorities. So for example, for musical works in Switzerland, you only can go to Suiza. So you don't have really a right to choose a collecting society. Of course, you can go to GEMA or in Germany or to SACEM in France, but within Switzerland, you don't have this possibility to choose. And as AIPPI does not request such possibility to choose, also here we can conclude that current Swiss law is compliant with the standards set in Q286. A last aspect of the resolution that I would like to address concerns royalties and their review. The resolution in its paragraphs 4 and 5 defines a number of criteria which should be reflected in national law when regulating the royalties, royalty rates that can be set by collecting societies. And actually all these aspects are addressed under Swiss law in the context of the so-called system of tariffs. And I would like to give you some overview very quick on the cornerstones of this system of tariffs in Switzerland. So important, it's a mandatory system of tariffs. If a collecting society wants to collect royalties for a specific use, it has to do that based on a tariff. It cannot do that, let's say, freestyle. And if a certain type of use covers the repertoires of multiple collecting societies, they are forced to work together to issue one tariff for that type of use. This results in what we call joint tariffs in Switzerland. Collecting society cannot just draw up tariffs in their backyard. No, they have to negotiate every tariff with the users' associations. So already before a tariff comes into force, users through their associations have the possibility to raise their voice and give input in the drafting of the tariffs. Of course, these negotiations, they do not take place in a vacuum, as the Copyright Act gives quite strict principles on the criteria that should be taken into account when setting the rates, and these have to be observed. And once the tariffs have been negotiated with the users' associations, they still have to be approved by an arbitral commission. And once that has happened, the rates are also binding for courts. So there will be no review for appropriateness before a civil court for royalty rates that are set in approved tariffs. Tariffs in Switzerland are public. They're published in the official Gazette of Commerce and also on the websites of the collecting societies. This sounds like a matter of course, but discussions with other groups in Istanbul showed that there are many countries where these tariffs are absolutely not public. And this was really important also for the resolution to request that the tariffs are made public. And what's also requested in the resolution is that the tariffs are limited in time. You don't have a specific rule in the Copyright Act requesting that, but it's clear that according to the practice of the Arbitral Commission, they will never approve a tariff that has no limit in time, because they would say, we're not able to judge now whether a certain rate is still appropriate in, let's say, 8 years. So all in all, here I can really say without hesitating that the current Swiss system is compliant with what is requested by AIPPI in Q286. And I will not shed light now on other aspects, but just my opinion is that all in all, Swiss law is compliant with what it's requested by AIPPI in its latest resolution on collecting societies.
Thank you very much.
That being
Fabian.
said, I have come to an end, and thanks for your patience.
Thank you very much for keeping up with time and for this very interesting presentation about collecting societies. Now is the time for questions from the audience. Do we have any? Okay, so I'm going to ask you one question, Fabian. You said that in Switzerland, by contrast to other countries, there's only one collecting society per category of works. What do you think of that, or what does the Swiss group think of that? Is it preferable this way? Is it better for the authors? Is it better for users? Is it better for both? Or would it be better to have kind of competition amongst collecting societies in Switzerland?
The short question is, it's better, yes. Why do you want more than one collecting society? You would like to have that because you believe that multiple societies, they might enter into some sort of competition, which makes them more efficient and which leads at the end of the day to more remuneration for right holders and at lower rates for the users. But at the end of the day, every collecting society has also an overhead, produces costs, and if you want to have multiple collecting society, you have to have market of a size that really allow you to multiply these overhead costs. Otherwise, the costs will exceed the benefits you will get from, let's say, more competition. And also from a user perspective, irrespective of the rates itself, it's easier just to have to contact one collecting society than to contact for this song collecting society A, for the other song collecting society B, and maybe for a third song you want to play on the radio collecting society C. I mean, that would not be a result that would be desirable from a Swiss law perspective, at least.
Makes perfect sense. Thank you very much, Fabian. If there are no other questions from the audience, we'll move to our last presentation. So our last presentation will be about responsibility of online marketplaces for online infringements. and we'll have the pleasure of listening to two speakers. First, Ellen Bruderer, who's an attorney at law with Hamburger and Zurich, and also listening to Hugh Reeves, who is also an attorney at law with Val de Vis in Lausanne. I think that Ellen, you will start first.
Yes, thank you, Thomas. So very happy to be here tonight. So as you will see, there's the members of the working group also displayed on the screen. So it was a working group mainly composed of lawyers. Give you the floor, Hugh.
Yes, thank you very much, Helen, for this. Thank you, Thomas, for the introduction. And it's a pleasure to be here. So I'm not sure I have control over the PowerPoint. No, I don't. But basically, Helen, if there's a way of moving to the second slide, because I don't have any control.
I'm on the second slide.
Yeah, or the agenda, the following slide.
Wait a second. I'll do it like this.
We're talking about the online stuff, and we're there we go. Yeah, perfect. Thank you very much. So the program for this evening, because I know it's getting late for some of you, especially those who are a tiny bit ahead in the time zone, different time zones, is to try and keep it simple and clear and show you what it's about, and then try to set out as simply as possible the findings and the resolution that was reached at the wonderful event in Istanbul. So Helen will start with some case studies to give a hands-on understanding of what we're talking about when we talk about the responsibility or liability of online marketplaces, and then the answers of the Swiss group, which are going to be published in the SIC for the readers of it, and I know there's a few around, and then yes, again, the findings from Istanbul. So Helen, I'll let you take it from there on these two topics.
Yes, so let me start with two small case studies just to set the scene. So the first case study is a very simple one. Here you have fake Rolex watches, which are sold on the Facebook Marketplace. So the scope of our study was focused on, for instance, Facebook as an online marketplace. So what is its liability, civil liability, when, for instance, fake goods are sold on this on its website? You can see here that the price of the goods displayed shows that it might be a fake product. And the second case study is also quite simple. So it is the one of eBay. So in this case, the seller is not eBay itself, but the third party, which is selling fake goods. So here it's a copy of a Louis Vuitton bag sold under the name of Chloe. So there's trademark infringements. So the scope of our study was quite simple. It only focused on industrial property rights, so trademark, patents, and industrial design. So it excluded copyrights. All type of online platforms which offered, for instance, third parties goods weren't captured by the study, and we only focused on civil liability and not criminal liability. And we did not address the question of when, for instance, Facebook was selling fake goods under its own name. This felt out of the scope of the resolution. So as Hugh has mentioned, we have been also asked a very, very comprehensive list of questions, and our answer will be published in the SIC, and we chose to sum it up quite simply. So first of all, I wanted to mention that the question as they were asked segregated. So the general IP law, general law regime, which is, for instance, the Swiss Code of Obligation. General IP law was, for instance, in Switzerland, the Copyright Act, the Trademark Act, the Design Law Act, and also digital law regime, which we do not know as per se in Switzerland, but maybe in other jurisdictions those exists. So our first conclusion in the Swiss report was that Swiss law does not contain statutory provision specifically addressing the question of online market space. So it is the general law regime and the general IP law regime which governs the matter. And accordingly, dependent is that there are no legal provision which are allowing specifically OM to avoid any civil liability, i.e. there are no statutory safe harbor provisions that exists. So for instance, OM such as Facebook or eBay might be held civilly liable as a direct infringer if it stores and offers infringing goods on its own behalf. And also as a co-infringer if it allows the participation to an infringement as an accomplice or instigator. So for instance, if the goods are available on the website and so on. So as we said, no specific condition exists in Switzerland which may help the OM to avoid any responsibility. However, in the general law regime, so for instance, under the Swiss Civil Obligation Code, one might be exempted from any liability if the conditions are not met, such as fault and causation. So for instance, the condition of fault would not be met, for instance, if the OM did not know anything about those goods being sold on its website and so on. So there was a consensus amongst the members of the group that in the group's opinion, there was no sufficient efficient, expeditious remedies that existed under the current Swiss law to allow to seize and prevent IP infringements on online market space quite efficiently. So we thought that the legal mechanisms were maybe unsatisfactory for IP holder because those remedies were quite burdensome and might be also costly for the IP right holders. And we stated, at least in the report, that we thought that the measures that the Swiss legislator should take would be, for instance, notice and takedown mechanism that would allow, for instance, OM to respond promptly. So this would protect the IP right holder, but also the OM who could be, for instance, aware of those IP infringements. So I give now the floor to Hugh.
Thank you very much, Helen, for that. So taking over here, and this is the final part of the presentation, is to attempt to walk you through the resolution that was reached in October in Istanbul. To spoil it a tiny bit, I can say that from the Swiss law standpoint, or at least from our group's perspective, I believe we were quite happy with the outcome, which was actually generally very much in line with our hopes and expectations. It was also a good surprise, so to speak, to see that many of our colleagues around the globe within the AIPPI environment felt quite the same way. So let's dive into it, and I'll see. Do I have control of this PowerPoint? No, I don't. Okay, yeah, thank you. Sorry, Helen, I'm going to bother you every 30 seconds with it. Okay, so the first conclusion was that there's a general consensus that we need a special digital law. So as Helen explained, there's we've been seeing it in levels. So the general laws and the IP law, and then a need here for a special digital law regime that somehow takes into consideration, on the one hand, the interests of the online marketplaces, for a need for some form of safe harbor and protecting the rights of the rights of the IP right holders. Then, of course, what we do manage to have is a recommendation that countries adopt this digital law regime that includes safe harbors that are, as the name indicates, really offering some shelter to the OMs, the online marketplaces, if certain conditions are met. So, first of all, in order to be able to enter this playing ground, so to speak, of the special digital law regime, the OM, online marketplace, should keep a neutral or a passive role. This is a case-by-case analysis, and we have some factors to consider on that level. So here, and I'll just read from left to right, go from left to right in these boxes here. The OM should only provide third-party sellers hosting, the hosting of these third-party sellers. It should not implement a control over the activities of these third-party sellers, and the OM should not offer services, promotional services for what is offered for sale, nor optimization or presentation of the offers for sale, or services of storage or shipping of the products. This, in a way, would put the OM in a situation where it is enabling possible infringements. And then the last square down here, that as a user, we're not given the impression that the OM is providing or selling in its own name or account infringing products or even services. And this impression could come from, for instance, when the OM is not distinguishing very clearly its own offers for sale from those of third parties. So these are the conditions, again, a case-by-case analysis to see if the OM has a neutral or a passive role. If so, it does enter the special digital law regime and could benefit from the safe harbor conditions, as we'll see on the next slide right now. So here, if these conditions are met, then the OM is in a pretty good position, and by virtue of that, so would be the IP rights holders who can use the whole mechanism that we're hoping to put in place. First of all, the online marketplace must not have knowledge of the infringing character of the products that are offered for sale on the marketplace. If it does have knowledge, then it has to act expeditiously to remove the access to the infringing products on offer. Of course, this is vague wording in the sense of what is expeditious in one country and one jurisdiction is maybe not going to be the exact same in another country. But the notion is here. I do believe it is quite self-explanatory, so we are happy to see it in there as a condition. Then the OM has to provide the following, and this is sort of the crux of it. This, I think, is, at least for me, I believe Helen for sure as well, and the rest of the Swiss group too. What we were hoping to see is indeed the online notice and takedown, as well as a stay down procedure in place. So here, when the IP right holder does provide the notice, this will be a qualified notice that then gives right to the other party to file a counter notice. This is perhaps the crux of it, is a very important part. For those of you who do work with online platforms, not necessarily in your jurisdiction, but sometimes abroad, the whole notice and takedown process is valuable. It is not always easy to use. So this is going to be a lot of, or it's a good subject for conversation in any case. This also means that the OM has to provide exclusion of third-party sellers for repeat offenses, meaning reposting of infringing contents. The OM online marketplace has to monitor to a minimum standard the offers that are put there by third parties, and this standard should vary according to the technology reasonably available to the OM under consideration. This is perhaps also a hazy area to some of you who've been following who followed back in the day the copyright directive. We were talking about the Article 13 with the upload filters. This does sort of sound a tiny bit not dissimilar to that. So we have to see what technologically reasonable means, what that could imply, how expensive that might be for the online marketplaces, et cetera, et cetera. Another topic for another day. Then the online marketplace has to collect the name, address, contact info of the third-party sellers and verify that this information is indeed accurate and up to date, and provide this information to the IP right holders diligently. This did give, as I recall, a tiny bit of discussion around, of course, the data protection type of stuff, but this is also quite a logical consequence of having the notice and takedown and the stay down measures in place, and in order for the IP rights holders to enforce their rights. The remedies which we have here, if the special digital law regime, the safe harbor, applies, but that the OM did not comply with the conditions that we just described, then this protection vanishes. So the safe harbor is gone, and there is liability or responsibility under general IP law and general law, including remedies they put there for infringement under those various regimes. Of course, this is quite logical, but it's good that it is spelled out. Regardless of the online marketplace's liability under general law, under general IP law, we do want to ensure that courts can issue injunctions and court orders, etc. Otherwise, the system simply doesn't work. So the remedies are relatively straightforward as a logical consequence of the mechanism just described. Very good. So I think that wraps it up for our side of things. Helen, I don't know if you have other words to add, if I did justice to the subject and to the rest of the team.
Yes, you did.
I think you both did justice to the topic. Thank you very much, Helen and you. Do we have any questions from the audience? Okay, I'm going to ask one question before briefly wrapping up the webinar. You said that one of the conditions, or maybe the main condition to benefit from the safe harbor regime, which makes sense, is that the online marketplace plays a neutral or a passive role in order not to blur its services in a way, not to confuse the consumers as to what its role is. Again, in my opinion, that makes perfect sense, but it seems to me that precisely the tendency of these online marketplaces is quite to the contrary, that they play a role which is difficult to understand, to distinguish. Are they merely hosting? Are they offering their own products or services? Are they optimizing the ads and the sales? Do you think that this, as you call it, the special digital law, will force these online marketplaces to basically clarify their roles?
I'll have a stab at it, and then I'll let Helen give the definitive answer. It's a really great question. I think actually that is a very central question. We did spend quite a bit of time within the group in trying to understand where the world is at in 2023 in terms of online marketplaces, because as you say, there's different ways of buying stuff online. To cut to the chase, yes, this definition, if it makes it into law, and depending how it is phrased, of neutral or passive role, could have a significant influence on the online marketplaces. If I were them, I would try to look for the way to benefit from the safe harbor, and this could guide their behavior to quite a broad extent. And this neutral or passive role, in that way, can be seen as a rather blunt tool, in a sense, because it might push big online marketplaces into quite radical changes of behavior by refusing certain types of sales, by limiting the services that it is offering, etc. So no answer from my end. Helen will have the answer, just some thoughts. And again, it's a very good question.
Thank you, Hugh. Thank you, Thomas. So I think I concur with Hugh. Actually, I think it would be something quite positive if the big players would change their business model, and it would be all the purpose of the law to invite them to maybe modify their actions on the market and maybe tone down their intervention, for instance, as online marketplace, and have this passive role and implement actually the measures they are supposed to implement, so the notice and takedown and so on. So, but I think it will spark very, very interesting discussion in the future.
Thank you. If we don't have any other questions from the audience, it's time to wrap up very briefly. So thank you very much to our distinguished speakers. Thank you very much for AIPPI Switzerland and AIPPI International, and to all those of you who participated in this webinar, which I personally found very interesting. So I hope that you did as well. Thanks again, everybody, and see you next time. Bye-bye.